Welcome back to the Deep Dive, where we take a stack of dense sources, articles, and legal documents, and, well, we try to extract the clearest, most profound nuggets of knowledge for you.
And today we are really undertaking a massive deep dive. We're looking at a document that, while it's incredibly brief, holds the entire philosophy and, you could argue, the destiny of the Republic of India.
We're talking about the Preamble to the Indian Constitution.
Exactly. And, if you're looking for a shortcut to understanding what the Indian state is, what it wants to achieve, and who holds the ultimate power, the preamble is, quite simply, the answer.
It's the ultimate distillation.
It is. So our mission today isn't just to summarize it. We're going to unpack the ideological choices, the historical compromises, and the immense legal weight that's encapsulated within just that single, powerful paragraph.
I love that framing. It's about going beyond the text itself to explore, its origins and the pretty dramatic legal battles it's survived over the decades.
Yes.
And to set the stage, one of the most powerful descriptions I found in our source material came from the eminent Indian jurist Palkhivala.
Oh, yes.
He famously called the preamble the identity card of the Constitution.
And that analogy is just so helpful. I mean, think about it. An identity card is concise, right? But it establishes your name, your parentage, your core defining features, and your date of birth.
Everything essential.
The preamble does exactly that for the Indian state. It establishes who the authority is, we the people, what the state's objectives are, so justice, liberty, equality, and its fundamental nature, sovereign, democratic, and so on.
It's all there on one page. And tracing its lineage, it's worth a quick historical note that India wasn't exactly inventing the concept of a preamble.
No, not at all. The American Constitution was the first major constitutional document to use one way back in 1787. India, along with many other nations, followed that practice, recognizing just how useful such a concise, upfront philosophical declaration could be.
But India's preamble is uniquely its own.
Oh, absolutely. It's rooted entirely in its own founding moments and political aspirations. It's based directly on the Objectives Resolution, which was, it was the foundational statement of intent.
The one drafted by Pandit Nehru.
Drafted and moved by Pandit Jawaharlal Nehru on December 13th, 1946. It was then adopted unanimously by the Constituent Assembly in January 1947. That resolution really laid the entire philosophical groundwork for everything that came after.
And if you want an immediate hook, something that signals the kind of historical curiosity we're dealing with today, you just have to look at the fact that despite being this foundational text, the preamble has been amended only once.
Just once, in over 70 years of the Republic. That speaks volumes about the stability of the original document.
So when did this single amendment happen?
It occurred via the 42nd Constitutional Amendment Act in 1976, which is an amendment so vast it's often called the mini-constitution.
And that single act inserted three incredibly consequential words.
That's right. Socialist, secular, and integrity.
And that change alone tells you that the preamble isn't some static document sitting in a museum. It's a living testament to India's political journey.
Absolutely. It shows a move from implicit foundational concepts, things the original makers just assumed, to explicit constitutional declarations.
Particularly against the backdrop of the political shifts of the mid-70s, which was a very turbulent time.
Indeed. And it forces us to ask, why did the political establishment at that specific time feel the need to make these ideas so explicit? That tension is really central to our analysis today.
Okay, let's unpack this monumental document then. We have to start with the text itself because every single word in the preamble carries, an immense philosophical and legal weight. I'm going to read the preamble in its present full form because you really need to hear the rhythm and the power of this single declarative sentence. It reads,
It's a powerful piece of prose.
We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution.
It's more than just a grand opening. It's structurally designed to answer the most fundamental questions about the state. Our sources, I think, brilliantly break this powerful text down into four distinct ingredients or components.
And understanding these components is the first step.
It's the first step to understanding the Constitution's entire purpose, really.
So the first ingredient is maybe the most revolutionary concept in modern political history, the source of authority. And that is crystal clear right from those opening words, we, the people of India.
Exactly. This declaration establishes the bedrock principle of popular sovereignty. It signifies that the Constitution does not derive its power from any external sources.
So not from the British Crown, for instance.
Not from the British Crown, not from a religious text, not from some powerful ruler, but directly and solely from the people themselves.
In constitutional terms, what does that mean?
It means the ultimate legal sovereignty resides permanently with the citizens of the Republic. This one concept is the philosophical engine of the entire democracy that follows.
Okay, that's ingredient one. What's the second?
The second ingredient defines the nature of the Indian state. This is the declarative part where we get that powerful five-word grouping, including the additions from 1976.
Sovereign, socialist, secular, democratic, and republican polity.
Yes, and this section is the core of that identity card we mentioned. It's a definitional statement that establishes India's political, economic, and social character.
So it outlines the structure, but also the ideology.
That's a great way to put it. It outlines the structure of the political system representative democracy and simultaneously sets the ideological framework, socialism and secularism, which guides how that political system should operate. And as we'll see, this is the section that creates the most tension with India's contemporary reality.
The third ingredient then focuses on the objectives of the Constitution.
Yeah.
What is the Constitution actually trying to achieve for the people it governs?
Right. And it specifies four core goals.
Yeah.
Justice, liberty, equality, and fraternity. These are the aspirations.
The promises.
They are the moral compass, or the promise, if you will. The institutions created by the Constitution, the legislature, the executive, the judiciary, are all mandated to work towards securing these goals.
And even though the preamble itself isn't directly enforceable in court?
These objectives find their legal enforceability in the body of the Constitution, specifically in the fundamental rights and the directive principles of state policy. We'll get into that.
And finally, the fourth ingredient is the simplest one, the date of adoption.
November 26, 1949. The day the Constituent Assembly formally adopted, enacted, and gave this Constitution to themselves. It marks the precise historical moment of self-creation.
Which precedes its full implementation on January 26, 1950.
Correct. So when you put those four components together, authority, nature, objectives, and date, you realize the preamble is a comprehensive philosophical document. It answers the crucial questions. Who made it? What is it? What does it want to achieve? And when was this foundational covenant established?
Let's dive deep then into those five defining terms that describe the nature of the Indian state. We have to start with sovereign. What exactly does it mean for India to hold absolute sovereignty?
Sovereign is the declaration of total independence. I mean, it means India is absolutely free. It is neither a dependency nor a dominion of any external power.
So in legal terms, there's no higher authority.
No higher authority above the Indian state, period. India holds the supreme right to conduct both its internal governance, its laws, its policies, and its external affairs, its treaties and international relations, entirely as it chooses.
That sounds pretty airtight as a definition of independence. But the historical context, that introduces a little bit of a nuance, doesn't it? I'm thinking about India's decision to remain a full member of the Commonwealth of Nations.
A very important point.
If it accepted the British Crown as the head of the Commonwealth, did that in any way compromise its sovereignty?
That is a vital point for historical clarity. Our sources are very clear on this. India's declaration in 1949 about its continued full membership in the Commonwealth was purely an extra-constitutional declaration.
Meaning it wasn't part of the Constitution itself?
Exactly. It was a voluntary political decision. And the Founding Fathers were absolutely insistent that this membership could not be interpreted as a subordinate relationship.
So accepting the British Crown as the head of the Commonwealth was purely symbolic.
Purely symbolic. It doesn't grant the Crown any governmental power or authority over India. It's a voluntary association of independent states, and this relationship is explicitly stated not to affect India's core sovereignty in any manner.
And the same logic applies to its membership in the UN.
The exact same principle applies to India's membership in the United Nations Organization, or UNO. These are acts of a sovereign state choosing to participate in global governance. not limitations being imposed upon it.
Okay, so to stress the practical, ultimate power of sovereignty, what can the Indian state do that only a truly sovereign power can?
It all comes down to territory. Being fully sovereign means India possesses the ultimate right to make decisions about its own borders. It can acquire foreign territory, or, and this is always a crucial test, it can, if the necessity arises, and after following constitutional procedure, cede a part of its own territory to a foreign state.
The ability to unilaterally manage its own territory is the proof.
It's the definitive proof of independent final authority.
That makes the definition crystal clear. Now let's move on to the second defining term, the one that was added later in 1976. Socialist. Given India's economic path, this word carries a huge amount of weight.
It really does, and the historical context here is foundational. Even before the 42nd Amendment made the word socialist explicit in the preamble in 1976, the Constitution already contained a substantial socialist content.
And where was that content found?
Primarily in Part 4, the Directive Principles of State Policy, or the DPSPs.
And just for our listener, what exactly are the directive principles?
They are essentially non-justiciable guidelines. You can't sue the government over them, but they are directives to the state, aiming to promote social and economic welfare.
So things like securing a basic livelihood, equal pay for equal work.
Exactly, and preventing the concentration of wealth. These principles reflect a deeply embedded aspiration towards economic equality long before the word socialist was officially inserted into the preamble.
And this aspiration was also being signaled politically much earlier than 76, right?
Absolutely.
Yeah.
The ruling party at the time, the Congress Party, had already adopted a specific resolution back in its 1955 Avadi session, committing to the establishment of a socialistic pattern of society.
So when the 42nd Amendment came along, it was just making official what was already the stated political goal.
It was ratifying an established political trajectory and making that commitment explicit in the foundational text.
Okay, now this is where we really need to distinguish India's brand of socialism, because I think it's often misunderstood globally. It's not the Soviet model of state control.
That's the key distinction. India opted for what is called democratic socialism, and it must be sharply contrasted with communistic socialism, often called state socialism.
Which involves the state owning everything.
Correct. Communistic socialism, like in the USSR, typically involves the nationalization of all means of production and distribution, the complete abolition of private property, and highly centralized state planning.
But Indian democratic socialism, it takes a fundamentally different, more pluralistic path.
It does. It places faith in a mixed economy model. And this is critical. The public sector, so state-owned enterprises, and the private sector, they coexist side by side. The state aims to regulate, plan, and guide economic activity to serve social goals, rather than seeking the outright abolition of private enterprise.
So what's the ultimate aim of this uniquely Indian democratic socialism, according to legal and political interpretation?
Well, the Supreme Court has defined it very clearly over the years in various judgments. They emphasize that democratic socialism aims to end poverty, ignorance, disease, and inequality of opportunity.
So it's about welfare and justice, not state ownership for its own sake.
Exactly. It's a focus on welfare, social justice, and opportunity, all achieved through democratic constitutional means, rather than, say, violent revolution or a complete state takeover.
Ideologically, this blend is said to derive from two, well, pretty opposing philosophies.
Yes. The sources describe Indian socialism as this ideological blend of Marxism, with its focus on economic equality and class struggle, and Gandhism, which emphasizes nonviolence, a decentralized economy, and the upliftment of the masses, what they called Antyodaya.
And historically, India leaned more towards one than the other.
It has, yes. It has leaned more heavily towards Gandhian socialism, promoting self-reliance and the welfare of the poorest.
This is where the real contemporary tension lies, which our listener really needs to grasp. The preamble explicitly declares India as socialist, yet the economic path since 1991 has created a massive contradiction.
This is the crux of the ideological challenge. The new economic policy, or NEP, which was initiated in 1991, centered on liberalization, privatization, and globalization, the LPG reforms.
And these were a complete reversal in many ways.
A complete reversal. Liberalization dismantled state controls, privatization shifted ownership from public to private hands, and globalization opened the economy up to international competition.
So how does this fundamentally clash with the word socialist that was added just 15 years prior?
The clash is profound. The core idea of that 1976 socialist commitment was state intervention to control monopolies and ensure equitable distribution. The 1991 reforms, however, favored market forces, reduced the state's economic footprint, and promoted private capital generation as the primary engine of growth.
So when you see massive state-owned assets airlines, mineral companies being privatized, that's a direct example of this tension.
It's the most overt example. If the state is actively reducing its control and relying on private wealth creation, the explicit declaration of socialist in the preamble appears to be, well, significantly diluted.
Is the word now just a philosophical aspiration rather than a descriptive reality?
Many legal and economic commentators argue exactly that. The word remains constitutionally binding, which means the Supreme Court can still use the socialist principle to review legislation intended to protect the vulnerable. But in terms of day-to-day economic policy,
The ship has sailed.
the state has significantly retreated from the comprehensive, state-planned democratic socialism that was envisioned in the 1970s. It represents a permanent dynamic tension in India's constitutional identity.
A fascinating contradiction right there in the identity card itself. Let's move to the third key term, also added in 1976, secular.
The concept of secularism was treated very similarly to socialism made explicit later, but certainly implicit from the very start. The Supreme Court observed as early as 1974 that even though the words secular state weren't in the preamble initially, there was no doubt that the Constitution makers intended to establish such a state.
And the evidence for that original intent lies right in the body of the Constitution, specifically in the Fundamental Rights section.
Precisely. Articles 25 to 28 guarantee the fundamental right to freedom of religion. These provisions guarantee that every citizen has the liberty to practice, profess, and propagate their religion. And importantly, they ensure that the state cannot force citizens to pay taxes to promote any one particular religion.
So these articles laid the philosophical groundwork for a secular state long before the word was even added to the preamble.
They absolutely did.
Now, let's go deeper into the distinction here, because the Indian model of secularism is fundamentally different from, say, the US or the French model. We need to fully explain what the material calls the positive concept of secularism.
This distinction is crucial for understanding the Indian polity. In many Western contexts, often called negative secularism, secularism implies a strict, unbreachable wall of separation between the state and religion.
The total separation.
Total separation. The state maintains neutrality by non-interference and, critically, non-support. Religion is seen as an entirely private matter.
But the Indian model is different.
It is the positive concept. This means the state must maintain an attitude of equal respect and equal support toward all religions. The state doesn't endorse one religion, but it can and does support or even intervene in all religions to ensure fairness and equality.
So all religions, regardless of their size or strength, have the same status and can receive equal support from the state.
That's the principle.
Can you give us a concrete example of this positive intervention?
A classic example is state funding for pilgrimages or for the upkeep of religious institutions of multiple faiths. That would be impossible under a strict negative separation model.
And it goes beyond just funding.
Oh, yes. More importantly, the state also reserves the right to intervene to reform social practices within religions in order to uphold constitutional values like equality and justice. For instance, the banning of certain social practices or intervention in temple entry matters.
So the Indian state's neutrality isn't one of complete separation, but one of what's called principal distance.
That's the key takeaway. Principal distance versus a strict wall of separation. Now for the fourth term, democratic. This concept is, of course, central to the entire document. Based on that core doctrine of popular sovereignty, the supreme power is possessed by the people.
And when we talk about democracy, we know the power is with the people, but how they exercise that power can vary.
Right. Our sources differentiate between direct and indirect democracy.
Direct democracy, where citizens vote on laws themselves, is pretty rare today.
Yes. You see it primarily in smaller polities, like certain Swiss cantons. They use devices like referendum, a direct vote on a specific proposal, initiative, the power of the people to propose a bill, and recall removing an elected official before their term is up.
But India, being a vast and complex nation, uses the indirect model.
Correct. India employs representative parliamentary democracy. The people elect representatives who then exercise the supreme power, govern, and make laws on their behalf.
And the parliamentary part is crucial.
It's critical. Because it is parliamentary, the executive branch, the Council of Ministers, is responsible directly and continuously to the legislature for all its policies and actions.
What are the practical, measurable manifestations that prove India is a functional democratic polity beyond just the fact that it holds elections?
There are 5 core institutional characteristics highlighted in our sources. Universal adult franchise, so every adult citizen can vote. Periodic elections, which ensures accountability. The commitment to the rule of law, meaning no one is above the law. The independence of the judiciary to safeguard rights. And the explicit absence of discrimination on specified grounds.
So these mechanisms ensure that the popular will is translated into legitimate governance.
They do, but the term democratic in the preamble is used in an even broader, more philosophical sense than just these political mechanisms.
Right, it's not just about voting.
Absolutely not. The preamble is clear that its scope embraces not just political democracy, one person, one vote, but also social and economic democracy. This holistic vision was perhaps most powerfully articulated by Dr. B.R. Ambedkar.
This is where we need to spend some time on that profound quote from his concluding speech in the Constituent Assembly on November 25, 1949. The philosophical weight he placed on the future of the Republic is just immense.
It is. Ambedkar stressed that political democracy cannot last unless there lies at the base of it social democracy. He defined social democracy as a way of life that recognizes the trio of liberty, equality, and fraternity.
He was deeply concerned that just adopting a democratic political system would be totally insufficient if the deep-seated social hierarchies of India remained unchallenged.
He called this relationship the Union of Trinity.
The Union of Trinity.
Yes, and his point was that they are an inseparable union. You cannot divorce one from the others, because doing so defeats the very purpose of democracy. Think about the social context of 1949, riddled with caste and economic disparities.
Curse.
Ambedkar argued that granting political liberty, so the right to vote without first securing social and economic equality, would simply lead to the supremacy of the few over the many.
The powerful would just use their existing social and economic clout to manipulate the political process.
Precisely. Liberty for the elite would become license, and the disadvantaged would find their vote almost meaningless.
And he also warned about the reverse.
He did. He noted that equality without liberty would stifle individual initiative and lead to authoritarianism. And without fraternity, that sense of common brotherhood, liberty, and equality would never create a stable, cohesive society.
So his warning was crystal clear. The Constitution gave India political democracy, but it was up to future citizens to achieve the much harder goal of social and economic democracy, or the whole political structure would eventually collapse.
A sobering, powerful warning.
It certainly puts an immense philosophical obligation on the rest of the preamble's objectives. But first, let's wrap up the nature of the state with the 5th key term, republic.
The term republic is best defined by its contrast with a monarchy. In a monarchy, like the United Kingdom, the head of state holds a hereditary position. In a republic, like India, the head of the state, the president, is always elected.
Either directly or indirectly for a fixed term. In India, the president is indirectly elected for a fixed 5-year term. That's the technical distinction.
Correct, but the term republic implies 2 more fundamental things, embodying core democratic principles that go beyond just who occupies the top office.
Okay, what are they?
First, it reiterates that political sovereignty is vested in the people, not in a monarch or a single ruling family. It reinforces that opening "We the People" declaration.
And second, it implies the absence of any kind of privileged class. This is an explicit promise to dismantle the old feudal order.
It is a critical anti-feudal principle. It ensures that all public offices, from the lowest bureaucratic position to the highest constitutional post, are open to every single citizen without discrimination. There is no special birthright or aristocracy that grants preferential access to power or public life.
A vital principle for establishing meritocracy in governance.
Absolutely.
So we've established the structure and the nature of the state. Now we turn to the preamble's 4 aspirational objectives: justice, liberty, equality, and fraternity, which are, in essence, the promises made to the people.
Yes, and the first is justice, specified in 3 distinct forms: social, economic, and political.
What's fascinating here is tracing the ideological source of this ideal of justice. Our source material points out that it was explicitly taken from the Russian Revolution of 1917.
It was, which shows just how the Constituent Assembly was drawing on global revolutionary thought to shape India's future.
So let's break down the 3 types, starting with social justice.
Social justice mandates the equal treatment of all citizens. This means the complete absence of social distinction based on caste, color, race, religion, sex, and so on. But it's more than that.
It's not just passive.
No, it also actively involves the abolition of privileges for any particular section of society. And critically, it demands proactive measures for the improvement of conditions for historically backward classes, specifically the scheduled castes, scheduled tribes, other backward classes, and women.
So it's not just non-discrimination, it's active rectification of historical wrongs. Okay, next is economic justice.
This is secured by that spirit of democratic socialism we discussed. Economic justice means non-discrimination between people based on economic factors. Its core function is the systematic elimination of glaring inequalities in wealth, income, and property.
So preventing wealth from concentrating in the hands of a few.
That's the goal. And when you combine these two, social and economic justice, you get a specific legal concept.
Which is distributive justice.
Exactly. It's the state's obligation to distribute socioeconomic benefits and opportunities equitably. The state achieves this through policy, often using its power to implement things like land reform, progressive taxation, and reservations in education and employment. It's about actively reducing historical disparities.
And finally, political justice.
Political justice is simpler in scope, but crucial for democracy. It just ensures that all citizens have equal political rights, equal access to all public offices, and an equal voice in the government, all protected by mechanisms like the universal adult franchise.
And all these ideals are secured through enforceable guarantees elsewhere in the Constitution, making the Preamble's goals tangible.
Precisely.
Okay, moving on to the second objective, liberty. The Preamble secures liberty of thought, expression, belief, faith, and worship. We learned that this ideal, along with equality and fraternity, was taken from the French Revolution of 1789 to 1799.
Liberty, conceptually, means two things at once. First, the absence of irrational or arbitrary restraints on individual activities, and second, the active provision of opportunities for the full development of individual personalities. It's the essential oxygen for a healthy, dynamic democracy.
And this liberty isn't some vague political idea. It's constitutionally guaranteed and legally enforceable.
It is. The 5 specific types of liberty mentioned, thought, expression, belief, faith, and worship, are given legal teeth through the fundamental rights, specifically in Articles 19 and 25. If these rights are violated, a citizen can approach a court of law for enforcement.
Which makes the Preamble's objective a reality. But here is the critical caveat that often gets missed. The sources make it very clear that liberty does not mean license.
That is the ultimate check and balance. The liberty conceived by the Preamble is qualified, not absolute. It must be enjoyed within the limitations and reasonable restrictions explicitly mentioned in the Constitution itself.
For example,
the freedom of speech, or liberty of expression, guaranteed under Article 19, is subject to restrictions related to public order, morality, and the sovereignty of India. This ensures that individual freedom doesn't descend into chaos or infringe upon the rights or security of the larger community.
the third objective is equality of status and opportunity. Another ideal from the French Revolution, and crucial for realizing Ambedkar's vision of social democracy.
Yes. Constitutionally, equality means the absence of special privileges for any section of society, and the provision of adequate opportunities for all individuals without any discrimination. The Preamble aims to achieve equality across 3 distinct dimensions: civic, political, and economic.
So let's detail how the Constitution ensures civic equality through the fundamental rights.
Civic equality aims to establish a level social playing field. Our sources detail 5 specific articles that guarantee this. There's Article 14, guaranteeing equality before the law.
Article 15, which prohibits discrimination on grounds like religion, race, caste, or sex.
Then Article 16, ensuring equality of opportunity in public employment. Article 17, demanding the abolition of untouchability, which is maybe the clearest expression of social justice in the fundamental rights.
And finally, Article 18, providing for the abolition of titles, trying to eliminate inherited aristocratic privilege.
That comprehensive list really does systematically dismantle the hierarchies the founders inherited.
The Constitution also secures political equality.
This is secured through 2 key provisions. First, Article 325 ensures that no person can be declared ineligible for inclusion on electoral rolls based on religion, race, caste, or sex. Everyone counts equally. Second, Article 326 mandates that elections must be conducted on the basis of adult suffrage.
One adult, one vote, one value.
One vote
equal political currency. And finally, you have economic equality, which is secured primarily in the non-justiciable directive principles.
Specifically, Article 39.
Yes, which secures for both men and women the equal right to an adequate means of livelihood and, importantly, mandates the state to ensure equal pay for equal work. It forms the foundation for later legislation aimed at mitigating economic disparity.
The final objective, then, is fraternity, meaning a sense of common brotherhood. The preamble states that this objective assures two things: the dignity of the individual and the unity and integrity of the nation.
The promotion of fraternity is woven into the constitutional fabric in several subtle but powerful ways. The primary mechanism is the system of single citizenship.
Meaning there's no separate state citizenship like in the U.S.?
Exactly. This is meant to prevent regional or state loyalties from overriding a unified national identity.
And this commitment was later solidified through the addition of the fundamental duties.
Absolutely. Article 51A, inserted by that same 42nd Amendment, established the fundamental duties, one of which explicitly states the duty of every citizen to promote harmony and the spirit of common brotherhood among all people, transcending all these diversities.
So it makes fraternity a reciprocal duty expected from the citizen, not just a promise from the state.
A very important distinction.
Let's look closer at the dual assurance of fraternity, starting with the dignity of the individual.
K.M. Munshi, a key figure in the drafting committee, saw this as the recognition that the personality of every single individual is sacred. It ensures the Constitution doesn't just guarantee material betterment, but respects the inherent worth of every human being.
And this is protected through the fundamental rights.
Yes, through rights like the right to life and personal liberty, and reinforced by the fundamental duties, specifically the duty to renounce practices that are derogatory to the dignity of women.
And the second assurance, the unity and integrity of the nation. This is where that third word added in 1976, integrity, becomes significant.
That word addition was politically vital. This assurance embraces both the psychological cohesion and the territorial integrity of the nation. Our sources remind us of Article 1, which describes India as a union of states.
A very deliberate choice of wording by the founders. Why union of states instead of, say, federation?
To signify the indestructible nature of the Indian Union. Unlike certain federations where states might possess a theoretical right to secede, the Indian states have no such right. The union is permanent. The term integrity, added in the preamble, just reinforces this territorial and emotional commitment.
So the ultimate goal of this integrity objective is to combat those forces that threaten national cohesion.
Exactly. It sets a high bar for overcoming major internal hindrances to national integration, things like communalism, regionalism, casteism, linguism, and secessionist movements. The preamble is a solemn resolve that the nation must remain united in every single sense.
We've established the text and the philosophy of the preamble. Now we have to explore what it means, its significance, and the fascinating, often dramatic, legal journey it has undertaken through the Supreme Court.
This is where the legal controversy truly comes alive.
Philosophically, its significance is just immense.
It is. The preamble captures the basic philosophy and the fundamental values, political, moral, and religious, upon which the entire framework of the Constitution is built. It's the crystallization of that grand and noble vision, reflecting the collective dreams and aspirations of the Founding Fathers.
And to really emphasize this significance, our sources highlight some incredibly powerful quotes from eminent legal and political figures. I think we should delve into these tributes to convey the sheer respect this document commands.
Let's. Sir Aladi Krishnaswamy Iyer, a core member of the drafting committee, viewed it as the ultimate summary. He said the preamble expresses what we had thought or dreamt so long.
He saw it as the written manifestation of these long-held national desires for a free, just society.
Then you have K.M. Munshi, another key member, who gave it a more intimate, almost prognostic title, The Horoscope of Our Sovereign Democratic Republic.
A horoscope that suggests it not only describes the state at its birth, but also charts its destiny and character.
I think that's exactly what he meant. And then we have Pandit Thakur Das Bhagava, who provided the most comprehensive tribute using three distinct metaphors. He called it the soul of the Constitution, a key to the Constitution, and a jewel set in the Constitution.
He argued it was the proper yardstick against which the worth and intent of the entire constitutional document should be measured.
And importantly, this reverence wasn't just confined to India.
Not at all. Sir Ernest Barker, a highly distinguished English political scientist, paid what is maybe the most glowing international tribute. He described the preamble as the keynote to the Constitution.
He was so moved by the philosophical clarity and power of the text that he actually quoted the Indian preamble at the opening of his popular book, Principles of Social and Political Theory, back in 1951. It was an instant classic in constitutional thought.
Finally, there's the observation from M. Hidayatullah, a former Chief Justice of India, which places the preamble's resolve in a global context of permanence.
Hidayatullah observed that the preamble resembles the American Declaration of Independence, but, he argues, it is more than a declaration. He called it the soul of our Constitution, containing a solemn resolve which nothing but a revolution can alter.
Nothing but a revolution can alter. That phrase just conveys the gravity of the preamble's core principles. They are meant to be foundational and irreversible.
Exactly.
But if it contains the soul and charts the destiny, that raises the absolute critical legal question. Is the preamble actually a legally binding part of the Constitution? This issue became the subject of a massive legal controversy that really defined judicial review in India.
This legal evolution is essential for understanding the preamble's modern status. The initial view came in the Barubari Union case of 1960. This case concerned the power of Parliament to cede Indian territory to Pakistan under an international agreement.
And how did the court treat the preamble in that case?
Well, the Supreme Court recognized its importance. They agreed that it serves as a key to the minds of the makers and is highly useful for interpreting any articles in the main text that might be ambiguous. However,
There's a big however.
a very big one. The court delivered a major blow to its status, specifically holding that the preamble is not a part of the Constitution itself. It was viewed as introductory text, like a preface to a book, but lacking the binding power of the chapters that follow.
So for over a decade, the court effectively said, it's beautiful and useful, but it's not legally operative.
That was the position. And that ruling stood until the landmark case of Kesavanapurati versus State of Kerala in 1973.
This is the pivotal moment in Indian constitutional history.
It is. The Kesavanapurati case dealt directly with the limits of Parliament's power to amend the Constitution. The petitioners argued in part that the goals stated in the preamble, justice, liberty, equality, were so fundamental that they could not be altered.
And the Supreme Court, in a deeply divided 7.6 verdict, explicitly rejected the earlier opinion from the Barubari judgment.
It did. The court held that the preamble is a part of the Constitution and is of extreme importance. It ruled that because the preamble embodies the Constitution's fundamental features and structure, the entire document must be read and interpreted in light of the grand and noble vision expressed within the preamble.
So that instantly elevated the preamble from a mere preface to a foundational legal structure.
It did. And this position was reaffirmed later, ensuring legal stability and permanence.
In the LIC of India case of 1995.
Yes. The Supreme Court once again reaffirmed that the preamble is an integral part of the Constitution. So the current settled legal position is that the preamble is not just a nice introduction, but a core component of the constitutional identity.
It's still a bit puzzling, though. If it was meant to be so central, why was there ever any doubt, and why was it enacted after the rest of the Constitution?
That procedural detail is a great little anecdote. The preamble was actually enacted after the rest of the Constitution had been passed, clause by clause.
Which seems back.
It does, but it was done for a very specific logical reason, to ensure perfect alignment. The Constituent Assembly needed to be certain that the philosophical goals stated in the preamble, the mission statement, aligned precisely with the final, complex legal text they had just adopted.
So it was a procedural check to ensure conformity.
Exactly. And this intent was evidenced when the president of the Constituent Assembly literally put the question to the Assembly. The question is that preamble stands part of the Constitution, and the motion was adopted.
Which confirmed the will of the Founding Fathers, a will the Supreme Court finally backed in 1973.
Correct. But even as an integral part of the Constitution, the preamble has specific and very important limitations. It's not a source of enforceable law itself, is it?
That's the crucial distinction.
It is. We have to clarify two crucial limitations for our listener. First, the preamble is not a source of power to the legislature, nor is it a prohibition on legislative powers. It cannot grant or deny the government the ability to make a law.
And second, and most importantly for anyone thinking of going to court, it is non-justiciable.
Meaning, you cannot directly enforce its provisions in a court of law. For instance, you can't sue the state based solely on the preamble's promise of economic justice. If you want an enforceable right, you have to rely on the specific articles found in Part 3, the fundamental rights, or other enforceable provisions.
So the preamble provides the spirit, but the articles provide the legal framework.
A perfect summary.
This non-justiciability leads us directly to the question of amendability. If it's part of the Constitution, can Parliament use its amending power under Article 368 to change the preamble?
This question was central to the Kesavananda Hardy case in 1973, and the court's verdict here created one of the most powerful doctrines in Indian constitutional law.
The petitioners argued that the preamble, as a reflection of the nation's original spirit, should be untouchable.
They did, but the court adopted a more nuanced position. They held that it can be amended.
Okay, so they said, yes, it is amendable.
Yes. The Supreme Court held that the preamble is amendable under Article 368. This, in fact, validated the 42nd Amendment of 1976 that inserted socialist, secular, and integrity. It was a retrospective validation. But
Another big but.
the ultimate restraint. They said Parliament's amending power does not extend to destroying or damaging the basic features or fundamental elements of the Constitution that are contained within the preamble.
And that is the cornerstone of the basic structure doctrine.
Precisely. The basic structure doctrine says that the core identity of the Indian Republic, things like popular sovereignty, judicial independence, secularism, democracy, freedom, all derived heavily from the vision of the preamble, are unalterable.
So it provides a permanent legal guardrail against any majoritarian attempt to fundamentally change the nature of the Indian Republic defined by the founders.
It simultaneously accepts the necessity of change while protecting the absolute essence of the nation's philosophical identity.
This has been a really intensive deep dive into the identity card of the Constitution. To synthesize the immense detail we've covered, let's just briefly recap the core takeaways.
For sure.
We learned that the preamble is structurally designed around 4 key ingredients: the people as the absolute source of authority, the state's complex nature, the 4 fundamental objectives, and the date of adoption.
We also gained, I think, a lot of clarity on the massive ideological shifts, particularly contrasting India's democratic socialism, that mixed economy model aimed at welfare, from the communistic state socialism.
And we highlighted the necessity of understanding India's positive concept of secularism, where the state maintains a principled distance, supporting all faiths equally, rather than that strict separation you see elsewhere.
And perhaps most critically, we tracked that dramatic legal shift from the Supreme Court saying the preamble was not part of the Constitution in 1960 in the Brewbury case to emphatically declaring it an integral part in 1973 in Kesavananda Bharati.
Thereby subjecting it to the protection of the basic structure doctrine, even while validating those 1976 amendments.
And it's vital to reiterate one final conceptual point. While the preamble sets out the grand, non-justiciable goals of justice, liberty, and equality, the real-world enforcement of these rights occurs within the specific, judicially enforceable articles, the fundamental rights.
The preamble provides the spirit and the direction. The articles provide the law.
Couldn't have said it better myself.
Which leads us to our final provocative thought for you to consider, based on the legal landscape we've explored. The preamble contains non-justiciable concepts. These are ideals you cannot sue the government over.
Right. And yet these very concepts form the bedrock of the basic structure doctrine, and this doctrine limits the power of a democratically elected parliament.
So ask yourself, if the preamble itself cannot grant or prohibit power, what does it mean for the future of Indian democracy that these high-minded foundational values, the identity of the Constitution Act, as a permanent, unalterable limit on the democratic will of the people, as exercised through their elected representatives?
How does that constitutional mechanism balance the immediate will of the majority against the foundational, enduring philosophical commitments that were codified at the nation's birth?
It forces a continuous, profound dialogue between present choice and past covenant. And that continuous dialogue is the essence of why the preamble truly is the soul of the Constitution. Thank you for diving deep with us.